Today I shall try to focus on the available leaked or released text of TTIP and pinpoint which aspects could be considered to tie the hands of the future government insofar as NHS arrangements are concerned, and which aspect could be considered to offer some sort of protection within the context of the potential or prospective investor-state dispute settlement. Now, arguing that the TTIP will affect the NHS arrangements is not scaremongering. Nonetheless, at the present state, there can be no legal certainty, especially as to the precise position of the negotiating parties. Now, before proceeding with the actual findings, it is interesting to address a more fundamental question. How come the EU may negotiate a trade and investment agreement insofar as social and health services are concerned, if one takes into consideration that according to the Treaty on the Functioning of the European Union, healthcare services and national health policies constitute a matter of national concern. So before the entry into force of the Treaty of Lisbon, in the European Community Treaty, we used to have a sectoral carve-out for inter alia social and healthcare services. So the negotiation and conclusion of agreements relating to social and healthcare services used to be a matter of shared competence between member states and the community. So after the Treaty of Lisbon, it is an exclusively EU competence, which means that competent for the conclusion of these agreements is only the EU, subject to unanimity in the Council, where these agreements might be considered to constitute a risk for the national organization of healthcare services. Now, anyway, it is interesting to contemplate in which ways TTIP would be able to substantially restrict the freedom of a national government to organize the NHS at will. First of all, TTIP could serve as a market-opening tool for US private and profit-oriented providers, healthcare providers, who would be incentivized to focus on the economically profitable sector of the market. And there is a danger that they might embark on risk selection practices on the basis of population density and health risks. Now, this is of particular relevance for benefit-in-kind beverage NHS systems, which heavily rely on planning and on a solid network of incumbent local providers. So, and if that might sound a little bit a form of protectionism or arbitrary, it is worth mentioning that it constitutes one of the features of the European social model. Actually, the EU judiciary has on many occasions clarified that the danger of supply-induced demand necessitates resort to a net of incumbent providers, and at the same time that new entrants in a healthcare system that operates in full capacity could jeopardize its financial stability and could lead to its risk selection. Next, in the absence of a safety net for the NHS, TTIP might entail compensation requirements within the context of investor-state dispute settlements in the case where a state decides unilaterally to redefine the borderline between public and private provision and to repatriate some powers to the public sector. So if we want to substantiate those risks, we need to read carefully the framework agreement and the annexes and look for any derogations and reservations that pertain to the NHS and that provide absolute immunity to the NHS. So regardless of any assurances by the negotiating parties, we need to have those reservations copy-bottomed in the text. I think that we don't at the present moment. So far as market access and national treatment. Now, market access entails the obligation of host states to enable foreign investors to have access to specific economy sectors and is associated with investment liberalization. National treatment entails the prohibition of direct and indirect discrimination against foreign investors. Now, those two obligations are articulated in the chapter on cross-border trade and services. According to this chapter, said obligations do not apply to services that are supplied within the context of the exercise of governmental authority. So, they do not apply within that context, and they do not apply in services that are listed either in Annex 1 or Annex 2. So one may wonder, are NHS services supplied in the context of governmental authority, and if not, are they properly listed in an annex? I'm afraid not. First of all, services supplied in the exercise of governmental authority are those that are supplied neither on a commercial basis nor in competition with one or more service suppliers. Actually, the NHS in England, for instance, seems to operate both on a commercial basis and in competition with one or more service suppliers. Although NHS Foundation trusts do not have an explicit incentive to make profit, they may nonetheless raise capital from both public and private patients, and they may retain financial surpluses for future investments. Next, following the Health and Social Care Act of 2012 and the NHS Procurement, Patient Choice and Competition Regulation of 2013, NHS commissioners purchase healthcare services from NHS and private providers. So both public and private providers compete with the aim of attracting patients and with the aim of securing that state resources are allocated to them. So therefore, any result with the exception of services supplied in the exercise of governmental authority is deemed to be ill-fated. Now, with regard to annexes, I shall focus on the EU-wide entry for healthcare services in Annex 2, which was released in July 2015. Thereby, it is mentioned that the EU reserves the right to adopt or maintain any measure with respect to the provision of all health services which receive public funding or state support in any form and are therefore not considered to be privately funded. So this sounds promising. Nonetheless, a litigious investor will definitely pick up on this inherent obscurity, because on the basis of a very strict textual analysis, the ultimate criterion is whether those services, those healthcare services, are privately funded. If they are subject to TTIP. So, specifically now with regard to market access obligations, it is interesting to identify what type of obligations those are. So, market access obliges contracting parties to refrain from adapting or maintaining barriers to trade, such as quotas, public monopolies, restriction on the numbers of suppliers, and so on. The problem is that public healthcare systems, by definition, resort to such restrictions because they need to alleviate moral hazards, risk selection practices, and information asymmetries which tend to predominate in unregulated markets. So, for instance, the 49% ceiling on the potential revenues from private patients that is imposed on NHS Foundation trusts could be considered to constitute a quantitative restriction and an impediment to market access under TTIP. So its removal under TTIP, unfortunately, would result in the marginalization of public patients. Now, in the fairly recently leaked document of the chapter on cross-border trade in services and with regard to market access obligations, there seems to be no absolute immunity for NHS services. It is nonetheless mentioned that only sectors listed in the prospective Annex 3 on which no leak is available shall be subject to the market access obligations. In July 2015, in Annex 3, in the released Annex 3, there was stipulated that only privately funded healthcare services shall be subject to the market access obligations. Again, this is promising, but the criterion of funding is unable to capture some very important aspects, such as the fact that we have a multitude of funding sources, especially in the NHS. And overall, so far as market access is concerned, there are some protections, some limitations on market access obligations in the leaked and released documents. Nonetheless, those limitations do not seem to encompass the entirety of the market access obligations. Now, closely intertwined with market access are issues of public procurement. And it is worth mentioning that within the context of the operation of the NHS, a way of keeping the NHS in public hands is in-house provision. So in the TTIP chapter on public procurement, it is not clear to me that there is an exclusion corresponding to the EU law in-house exception from the obligation to compete under procurement law. So when you have in-house procurement, in-house provision, you do not have to compete to put them out on tender, those services. So we might have the following paradox. We might see under TTIP EU private investors that will be barred from tendering, whereas US investors will be able to bypass the in-house provision exception on the basis of TTIP. So this may result in reverse discrimination so far as EU investors are concerned, and may lead to a two-tier provision within the NHS. Now, so far as the pure post-investment obligations are concerned, those are the fair and equitable treatment and the protection against indirect expropriation, especially indirect expropriation, is of immense interest. Now, the fair and equitable treatment is the most elusive obligation, which entails an obligation on the host member state to maintain a stable legal and business environment. And the protection against indirect expropriation also raises many controversies. For example, the termination of an NHS contract might be considered a form of indirect expropriation. So let's imagine the following scenario. We have a UK government that decides to repeal the NHS procurement, patient choice and competition regulations of 2013. On the basis of which clinical commissional groups are obliged when procuring services to give to private operators, to private providers the chance to tender. A US company which might have invested assets with the prospect of having contractual arrangements with NHS bodies might argue that its expectations on the basis of those regulations of 2013 were frustrated and that its investment lost value. In those cases, the fair and equitable treatment and protection against indirect expropriatory takings would be applicable. So, within that context, it should also be pointed out that although the insertion of post-investment standards of protections in TTIP is equivocal, since it is highly debated whether the EU has the competence to negotiate agreements on encompassing post-investment obligations, member states and the EU cannot do not have, from what it seems, the chance to submit the reservations on those obligations. So the only shelter is the right to regulate, which I'm afraid, under the way it is interpreted by arbitrators, does not offer protection. And more specifically, it will not, the right to regulate as an exception will not render automatically a measure that pertains to the NHS lawful and legitimate. And regulatory chill might, after all, occur. For instance, an EU member state might not draft particular legislation in anticipation of arbitration. It might chill legislation upon knowing the arbitration risks, or chill legislation after the outcome of a specific dispute. Now, as a concluding remark, endeavours to exonerate the NHS, both at the level of the EU and at the level of member states, have been made, but I hope that this analysis has shown that those endeavours do not suffice. We need a comprehensive carve-out of the NHS, both in the framework agreement and in the annexes, that will cover the full gamut of pre- and post-investment obligations. And anyway, if NHS is to change, or the European social model is to change, we don't need aggressive investors to do that. We don't need them to leverage systemic changes. There are other ways of doing it, if it's necessary. Anyway, thank you.